Good morning, and thank you for joining our webinar on the CFPB and FTC's war on junk fees and what you need to know about them. Next slide, please. My name is Ori Lev. I'm a partner in our Washington, D.C. office, represent companies in CFPB enforcement actions and investigations and counsel on consumer financial laws, particularly UDAP. And prior to private practice, I was a deputy enforcement director at the CFPB. I'm going to let my two other presenters introduce themselves, and then we'll dive right in. Chris?
Great. Thanks so much, Ori. Hello, everyone. My name is Chris Leach. I'm a litigation partner in Washington, D.C. with Mayor Brown. My practice focuses on FTC investigations and enforcement, and also counseling on the hodgepodge of matters the FTC does, again, focusing on, as Ori does, UDAP and advertising work, but also based on my background, I was at the FTC and the Division of Financial Practices. So I also counsel on some of those statutes that the FTC enforces there. Krista, turn to you.
Thanks. I'm Krista Beaker. I'm an associate in the Washington, D.C. office, and I represent companies in connection with CFPB and FTC enforcement matters. And I also do just general compliance counseling on a variety of consumer financial services issues. Turn it back to Ori.
Thanks. Next slide, please. So this is our agenda for the morning. We're going to talk about what the agencies consider to be, quote, junk fees, unquote. Let's talk about the FTC's rulemaking in this area, and then a variety of CFPB actions, a credit card late fee rulemaking, a bunch of deposit account fees they've taken issue with, and some other fees. And then we'll get to some takeaways for companies who are concerned about these issues. Next slide, please. So what is a junk fee? Next slide is a good question. This is a term that we've heard a lot from, I think, starting with CFPB Director Rohit Chopra, and is now bled into the FTC lexicon as well. And a while back, the CFPB issued a request for information about junk fees, in which they put forth sort of two definitions that you see up there on the slide. One is hidden back-end fees, and there are a couple key points here. One is, as you see at the end of that definition, these are not something a consumer will have chosen based on a front-end price. And the CFPB is concerned that consumers are not shopping based on these fees, right? When you're looking for a credit card, for example, you might look at the APR that you're going to be charged or rewards, but you're not really looking at what is a late fee. So there's a question of competition built into this hidden back-end fees. And hidden is kind of a tricky word there, because it doesn't mean you haven't disclosed the fees. It just means it's sort of hidden from the consumer's consciousness, I think, in the CFPB's mind. But it's a fee that's going to come up later in the transaction when the consumer's already bound to the transaction, is something the Bureau is concerned with. The second one, I think, is a little easier to deal with as a company, and that's fees that far exceed the marginal cost of the service they purport to cover. And as you see there, it implies that companies aren't just shifting costs to consumers, but taking advantage of captive relationships to drive excess profits. And we'll see some examples of those kinds of fees that the CFPB has highlighted as we go through some of the actions they've taken in the junk fee space. So two big buckets that the Bureau has sort of identified as problematic. I'm not sure junk fees are limited to those, but that's a helpful framework to think about this. And I'll turn it over to Chris to talk about the FTC.
Obviously, Ori has talked about the CFPB's version of junk fees. The FTC, I think, obviously, there's Rohit Chopra, the commissioner of the FTC, came from the CFPB, came from the FTC, and a lot of the folks who are sort of running the show now at the CFPB come from, I think, sort of the same, a lot of sort of the same intellectual circles. So, I mean, if you're trying to think about sort of where this FTC and the CFPB are coming from, and it's sort of, they have sort of the same brain, but with different arms and different powers and functionality. So a lot of the things you'll see are going to be roughly consistent, but maybe a little different. And that's sort of how you should think about sort of the way the CFPB and FTC look at these things. And just if you look through the two ways that the FTC has described a junk fee, and I think this is important just because each entity will, even if this rulemaking they're doing stuff doesn't end up being a thing, there's lots of enforcement action separately. But so the FTC also looks at, like what Ori had said, fees that don't actually do anything, that are they think are literally junk fees. They have a couple sort of examples throughout their history. The best is in the auto buying industry, auto buying space. They're very concerned with filling your tires with nitrogen, but making sure that it's air that's not just air, because air is mostly nitrogen. So in their view, they've described that as a junk fee because it doesn't actually do anything. But then Ori sort of referenced hidden fees, which really it's not clear why they're rebranding these as junk fees when in sort of the days of yore, i.e. a couple years ago, they would have just called these deceptive fees because you said that there would be no fees and yet you hid fees there, or that the product cost a certain amount, but it really cost more because there were fees sort of buried within disclosures, or that they were unauthorized fees that were unfair practices in violation of Section 5 of the FTC Act. So it's a lot of this is sort of, some of this is, it's sort of like there's something borrowed and something new with respect to how we think about junk fees. So let's move on to the rulemaking itself, because this is an area where there's been a lot of interest. So for some folks on the phone who might not be familiar with the FTC, I'm going to give just a very quick sort of level setting. So FTC obviously is a 100-plus-year-old agency that has an antitrust component and a consumer protection component. The focus on junk fees is coming from the consumer protection side of the fence, although with, just as Ori said, that there's always a competition hue over this, because the concern often is that because some fees are not sort of adequately disclosed, it might be impeding actual competition and consumers choosing products that they want. So this is something from a consumer protection lens, but the concepts that motivate these fees might sort of come from the competition side of the fence too. So now the FTC generally over its history has been a law enforcement agency. When I was at the agency, we were sort of cops without guns, we would investigate violations of the law and then sue companies or get settled or engage in settlements with companies who were amenable to that. When the FTC looks at fees, and just to be clear, this is not a new area. The FTC has been going after poorly disclosed fees for decades. But the cases involving unlawful fees have generally been brought under something called Section 5 of the FTC Act, which is the organic statute that prohibits unfair or deceptive acts and practices. And there's other, obviously, disclosure statutes that address fees that you might be familiar with. There's the Truth in Lending Act for consumer credit, the Restore Online Shoppers Confidence Act, or ROSCA, which if your company sells subscriptions over the internet, you probably are very familiar with, which requires express informed consent and disclosure prior to charging fees. And then for any of your companies that engage in telemarketing, the telemarketing sales rule is obviously a big deal and has some provisions with some real teeth involving disclosure of fees. And so for a long time, it's sort of the FTC was an enforcement first entity, and they were able to get substantial amounts. I think the statistics that they quote to Congress are sort of billions of dollars over the past decade involving collection of money that they return to consumers for Section 5 of the FTC Act. But there was a major roadblock that the Supreme Court put in place in 2021. There was a decision called, I think it was a Federal Trade Commission v. AMG. And in that case, the Supreme Court held that the FTC's longtime enforcement policy, which would be to go to federal court and get what they call equitable monetary relief for first-time violations of Section 5, that the statute didn't actually authorize that type of monetary relief. And so that really sort of pulled the pins out from the major enforcement program and the way that the FTC traditionally would have sought to recover money for consumers in connection with poorly disclosed or unauthorized fees. the FTC since, and this is something that I was a part of when I was at the agency, basically was left scrambling, trying to figure out how to not only sort of deal with cases that were already in the pipeline, which I unfortunately had several of at the time, but going forward basis, how do they essentially sort of rebuild and remake their enforcement program so that it really had teeth and they could get money back to consumers, which at least from the FTC's perspective is their overriding desire. And so one way that the FTC Act does allow the agency to get money is if they charge not a violation of Section 5, just an unfair deceptive practice, but a rule that the FTC writes that specifically defines a particular type of unfair deceptive act or practice. If they're able to successfully write that rule and defend it in court, et cetera, violations of those rules can carry much more substantial penalties, civil monetary penalties, and also consumer redress. And so to support that sort of big push, the FTC did several things after AMG came out. They have a new rulemaking section within the Office of General Counsel. And as you see, starting in at the end of 2021 through all of last year, launching, I think the last count was sort of between 6 and 10 rulemaking, some of substantially large size, like the commercial surveillance rulemaking and the rulemaking that would bar all non-compete clauses throughout the economy. Next slide, please. So with that table setting in mind, I'm going to turn to the junk fee rulemaking itself. This was first started in October of 2022 when they released something known as an advance notice of proposed rulemaking. And so just to level set as to what this is not sort of standard like notice and comment rulemaking. The FTC in the 70s, Congress passed a statute called the Magnuson-Moss Act that imposed a number of additional procedural requirements if the FTC was going to engage in rulemaking. And the first step is that in order to, if you're going to write a rule, before you even issue a proposed rule, you have to publish something called an advance notice of proposed rulemaking that essentially flags the issue, informs the public what types of rule you're contemplating, and then seek comment from the public. And so that's what this was. And the ANPR addresses junk fees, which, as we said earlier, sort of they've described as two buckets, which are fees that have little to no value to customers, or fees that are disclosed only much later in the process. And there are a number of examples that are described in the ANPR. And so they talked about ancillary products in connection with loans or other complicated transactions. The best example that the FTC has is in the auto space, frankly, where they have a completely separate rulemaking that would really transform a good chunk of the auto buying process. But they're very concerned that ancillary products in larger transactions are ways that that companies can, in their view, I think, sort of pad their bottom line by slipping in fees in an already relatively large transaction that helped the company, but that the borrower or purchaser might not notice in practice. The other two examples are very industry specific. They talk about resort fees, and this is, I think, a favorite of all regulators when they talk about hidden or quote junk pricing. Resort fees, which we all know anytime we're staying at a hotel, that's something that I think they're very focused on. And if there is a rule that comes out, I would be shocked if it didn't include resort fees to a certain extent. And the second is drip pricing, and this primarily involves live event pricing. This was a major source of discussion in the ANPR, and also there was a petition for rulemaking that the FTC discussed in depth from, I believe it was 2021 or 2020, that talked about wanting to require all-in pricing for live event ticketing, so that sort of when you're shopping for a ticket, et cetera, on one of the various websites, that it's sort of you actually see the full cost of the ticket, and not sort of you click on the ticket and then 5 or 6 clicks along the way you find out what the various additional sort of ticketing and processing fees are, which can obviously be substantial in terms of the total cost of the ticket. Now, I said that these this ANPR asked for questions for the public, and here the ANPR posed 21 questions, and you should take a look at those if you're interested, and that really will give you a sense of what the areas of focus are here. And I think the examples I talked about are, I think, give you a flavor, but really sort of going deep into some of those questions will give you really telegraph sort of their concerns. And if you're interested, we're happy to discuss. Now, if we could move on to the next slide, please. Now, next steps for this. This is just the first step in a relatively long process. So the comment period was extended for a period of time, and then it closed in February, and there were more than 6,000 comments filed. FTC comments, like frankly most rulemaking comments, if you look at the actual numbers, the vast majority are individuals who can use the regulations.gov form just to type in some of their own thoughts and reactions to the issue. But quite a number of business groups, industry groups also filed comments indicating their sort of concerns about the rulemaking, their experiences with the types of procedures there. And then also on the other side, there were a number of like state AG groups, consumer groups, discussing their preferred approaches to these issues. So it's a lot out there, and really, I think sort of if you're looking to sort of get a full suite of what the thinking is on these types of fees, this is probably one of the best public repositories of public thinking on this. And so now, obviously, these are now comments are all something that the FTC has now in order to proceed to the next step. Right now there's likely a team of very lucky FTC staff attorneys who are reading and responding and trying to incorporate all of these thoughts to see if they can proceed to the next step in the rulemaking process, which is the proposed rule. And this proposed rule is going to be, I think, much similar to the types of proposed rules you would be used to in sort of normal everyday APA rulemaking. There's going to be a proposed rule and then the statement of basis and purpose. But in addition, the FTC has an extra step that it needs to prove. In order to outlaw practice, it has to show that the specific practice at issue is prevalent in the economy. And so that's going to be something that I think folks looking at this proposed rules are really going to need to focus in on closely, because if we're talking about things like hidden fees or just sort of having a fee like disclosed in a way that a customer might not see, it's not clear that that would be a specific enough sort of type of practice for the FTC to outlaw. But we'll see what they decide to do. Now, after the proposed rule comes out, if there's disputed facts, and this is now we're going into special FTC rulemaking land. If there are disputed facts, the FTC is required to hold a hearing where interested parties will be able to, before a hearing officer, likely either a commissioner or the chief administrative law judge, Mike Chappell, they're going to be able to speak for some number of minutes and present their view regarding the facts and the basis for the rule itself. If this is something that I'm trying to think of the last time if the FTC has ever actually used this process before. I think Ori might know, but I'm not sure of the last time they ever used this. But lucky for all of us, the FTC is trying this one out tomorrow for its very first rulemaking on corporate imposter schemes, prohibiting those corporate imposter schemes or Social Security imposter schemes. So we're going to get our very first look to see how this process works, what types of arguments they make, and whether really just this will be a very interesting drawing room for, I think, the more consequential rulemakings that are coming down the pipe on things like privacy, negative options, and the privacy and negative options. Now, obviously, after if the commission goes through and decides that thinks it has a basis, it'll issue the final rule, and then we get to everybody's favorite part. We will sue everybody and see what the courts say about it. So that's if we get to this, then we'll have a fun time in court with everyone, and we'll look forward to seeing that happen. But this is going to be something that takes quite a bit of time. So I wouldn't hold your breath, but this is just something we can hopefully wait for and read some good PACER decisions from federal courts on this issue. The only thing I'll say before passing it to Ori is that this isn't the only place where the FTC is focusing on fees. I'll note in March 2023, there was a proposed rule issued to overhaul what's called the negative option rule. The negative options are just subscription plans, but this would be something that would really overhaul how federal law treats subscription plans of all types regarding simple cancellation, express informed consent, and really sort of sneaking in some more prohibitions that would really apply a special regime under FTC rulemaking processes to anybody who sells things using subscriptions. But so that's a stay in touch type of development. But I'll turn it over to Ori for some more CFPB stuff.
Thanks, Chris. So I was going to talk a little bit about the CFPB's credit card late fee proposal, because of all the things the CFPB has said and done about quote unquote junk fees. I think this is the one that's most impactful, both because it's an actual proposed rule, it's going to be the law as opposed to a lot of guidance they've put out that we're going to be talking about, and just its impact on the market. So we'll start with some background. The Credit Card Act itself provides that any penalty fees associated with credit cards have to be reasonable and proportional to the omission or violation to which they relate. So that's not a concept the CFPB made up, right? That's something that Congress itself has directed. And Reg Z, which implements the Card Act and which was promulgated by the Federal Reserve before the CFPB existed, sort of mimics that requirement, puts a little more meat on the bones. It talks about, the fee has to be in reasonable proportion of the total costs incurred by the card issuer as a result of that type of violation. So if you think about a late fee, reasonable proportion of the costs incurred as a result of the late fee, i.e., collection costs. And Reg Z also requires that those fee amounts be reevaluated every 12 months to ensure they're still reasonably proportional. So that A is pretty burdensome, and B is fairly open-ended. I think what reasonable proportion is in the eye of the beholder. But Reg Z also provides a safe harbor. And the safe harbor was set years ago by the Federal Reserve at a certain amount that's inflation adjusted. And today it stands at $30 for the first violation and $41 for every subsequent violation within 6 months. And that is adjusted for inflation every year. It applies not just to credit card late fees, but to any credit card fees that are subject to the Card Act. And then there's a provision in Reg Z that says, look, whatever the fee is, it can't exceed the dollar amount associated with the violation. So, for a late fee, you can't charge a late fee that's greater than the amount of the payment that is late. So that's the state of the world when Rohit Chopra finds it. Next slide, please. And the CFPB has now proposed a pretty radical change in how this works. And the proposal, and the next slide, we're going to talk about the rationales for it and then the sort of expected challenges to it. But the proposal itself is lower the late fee amount to $8 for all fees. So there's none of this, first fee is one amount and subsequent fees are higher. Everything is capped at $8. Instead of the fee being capped at the amount of the violation, it's capped at 25% of the minimum payment. And I should say, this is just about late fees. The Bureau in the proposal isn't talking about other credit card fees. The late fees are really the predominant fee that is charged. The Bureau's proposed to end the annual inflation adjustment. They say they'll just look at this on an annual ad hoc an annual ad hoc basis going forward. And of course, well, I don't know if of course, but that's just all about the safe harbor, right? companies can still rely on the Card Act provision and the Reg Z provision that allows you to calculate, fees that are reasonably proportional. If you do that every year, and what we've heard through the grapevine is I'm aware of at least one issuer that tentatively is planning to do that rather than lower their fees to $8. We'll see if that happens. It obviously imposes a burden and is likely to draw regulatory scrutiny for how did you determine the appropriate fee amount if you do walk down that road. So this was a proposed rule. This is APA rulemaking. The CFPB is not subject to the sort of onerous MAGMAS rulemaking that Chris was describing that the FTC is required to follow. So this was just a regular proposed rule seeking comment, notice and comment. Among the specific things the CFPB sought comment on were whether they should require that card issuers provide a 15-day grace period if they want to take advantage of the safe harbor, whether card issuers should be required to offer auto pay or some sort of notification if they wanted to benefit from the safe harbor, whether this change should apply to all credit card fees and not just credit card late fees. And then finally, the biggest bombshell was, should they just eliminate the safe harbor altogether? And so we'll see what kind of comments they get on that and what they do with that. Next slide, please. So this is a pretty hefty rulemaking. This is the rule. It's like 250 pages, I think, maybe more. No, 190 pages. And here, this is the sort of a summary of the CFPB's rationale for what they're doing. And of course, APA rulemaking, this is the rationale that's going to ultimately have to withstand judicial scrutiny. The Bureau noted that the current safe harbor amount that was established by the Fed wasn't actually based on any analysis of the costs of late fees, right? And under the Card Act, the fee is supposed to be proportional to the costs of the violation, that instead the Fed basically relied on what the market was doing at the time to set that amount. The Bureau noted that everybody is relying on the safe harbor today. Nobody is doing this annual calculation. The Bureau believes that fees that are too high can actually interfere with consumers' ability to make future payments, right? So on the one hand, you say, well, late fees are disincentive for people to pay late. CFPB saying, well, late fees so high, now consumers don't have enough money to actually make payments. And hearkening back to the definition of junk fee that I talked about earlier, the CFPB views this as one of those hidden back-end fees that consumers don't shop on, right? It's not something that's subject to competitive market forces where issuer is going to attract consumers by having a lower late fee. That's not how the market works. And that, given the revenue that issuers are generating from this, and the fact that the market, it's not a sort of a way to gain consumers, there's going to be a disincentive to lower the fees. So then the CFPB turned to its actual analysis. And what it did was it looked at 10 years of call data that big banks provide under law for other purposes. And this is data from institutions that have $50 billion or more in assets. So there aren't small companies in here. And the Bureau undertook what struck me as a pretty simplistic analysis. It took this call data and said, okay, well, we're going to see what is the total fee income from all these institutions from credit card fees, total late fee income. And now we're going to take the aggregate pre-charge-off collection costs because, right, the fee income is supposed to be proportional to the cost of the violation. And this is the data we have. Well, they didn't actually have pre-charge-off collection costs. They had total collection costs. And the CFPB said, well, it's only the pre-charge-off collection costs that are relevant because that's the cost of the late payment, is collecting it before charge-off. Once you've charged off the account, if you're seeking to collect that payment, that's not a cost of the late payment anymore. That's you trying to mitigate your balance sheet losses. And they said, well, we're going to assume that 75% of the overall collection costs are pre-charge-off costs. And they did some simple math and they said, well, the total fee income is 5 times larger than the pre-charge-off collection costs. And if those fees are supposed to be proportional to collection costs, they're 5 times too high. And the current fees are $41 for second, third, subsequent violations. So if $41 is 5 times too high, the right number is $8. So they literally divided the total fee income by their imputed pre-charge-off collection costs to come up with a factor that they then applied to the current late fee safe harbor amount. Then they said, $8 is still a deterrent. It actually may increase repayment, especially for subprime borrowers who now will have money available to pay because they don't have such a high late fee. As I said, they threw out the annual inflation adjustment because they said that inflation isn't really reflective of how the costs of collections on late payments have changed over time. And then they limited every late fee, right? It's $8, but it can't be more than 25% of the minimum payment that is late, because they think 25% should cover the contingency cost of pre-charge-off collection. So you shouldn't be charging a fee that's more than your cost of collecting that late payment. So those are the rationales that are set out in the rule. Next slide, please. So comment period closes today, actually, and expect a lot of comments on this. Several issues have been raised to date. The first is a technical one, and that is that although the CFPB isn't subject to the cumbersome rulemaking that the FTC has to undergo, the CFPB is subject to what's known as a SBREFA process, which is a small business regulatory review process. And it applies to any rule that is going to have a significant economic impact on a substantial number of small entities. And before the CFPB issued its proposed rule, industry trade groups wrote to the CFPB and said, you need to follow the SBREFA process because there are lots of small issuers out there, and any rule you are going to issue here is going to meet this criteria. The Bureau did not do so. They did not go through the SBREFA process. It's somewhat surprising to me because it's a little bit more burdensome, but it is not. It's nothing like what Chris was talking about in the FTC said. They need to put out an outline and hold a hearing, gather some input. So it would have slowed them down a bit. I've got to think that the attorneys in the legal division of the CFPB have determined they've got a good defense to this, because when the lawsuit comes, and a lawsuit or lawsuits will come, likely in Texas, this will be the first claim, right? This rule is invalid because it didn't follow SBREFA. And then the other challenges we expect to see relate to the data set, right? That it only represents larger issuers and it didn't contain the kind of granular level data that would support a true analysis, and that the Bureau's analysis is overly simplistic here. That the Bureau's failed to properly account for the deterrent effect of late fees, and that $8 is not sufficient to deter late fees, and that there'll be changes in consumer behavior, right? If there's a lower late fee, you're going to have, in theory, more late payments. That's going to drive up costs. And the argument that the lower safe harbor amount will ultimately harm consumers in the form of either higher APRs on cards and tighter credit limits on cards. The CFPB said they plan to finalize this rule by the end of this year. That's pretty ambitious and quick. There will be litigation. It will likely be in the Fifth Circuit, where because that is the circuit that's ruled that the CFPB's funding structure is unconstitutional and has struck down another rule. That case, the constitutional case, is before the Supreme Court. Whether the late fee rulemaking gets stayed until the Supreme Court case is decided, we'll see. I think that's likely if there is a challenge in the Fifth Circuit. So this is all ultimately likely going to play out in court over the next couple of years. I'll be back to talk about some more CFPB developments later.
Thanks, Ori. So a significant part of the CFPB's campaign against junk fees has been focused on non-sufficient funds fees and overdraft fees. The CFPB has made it quite clear that it does not like these fees. And so overdraft fees, financial institutions may charge an overdraft fee if they offer an overdraft program and the consumer opts into that program, and then the financial institution chooses to cover a transaction that exceeds the consumer's account balance. And kind of the flip side of that coin, if the financial institution doesn't cover a transaction that exceeds the consumer's account balance and instead returns it unpaid, the financial institution may charge the consumer this NSF fee, or this non-sufficient funds fees. So overdraft fees and NSF fee policies vary by institution, and they can even vary by account type offered at that institution. So for example, a bank might offer an account for which it doesn't charge any NSF fees, or only charges a limited number of NSF fees, like one per day or something like that. And according to the Bureau, NSF fees and overdraft fees are typically flat fees charged on a per transaction basis, and they average around $35 each. The CFPB has released several reports looking at NSF fees and overdraft fees, and the Bureau thinks that banks have historically relied very heavily on these fees, with NSF fees and overdraft fees accounting for nearly 2/3 of financial institutions' fee revenue in 2019. With respect to NSF fees, the CFPB has said the cost of the institution to return a payment is likely very low, and there may not be really any cost at all. And so this $35 fee is not in proportion to the cost that the institution faces. The CFPB has also said that since all banks do is return a payment, consumers receive, quote, no service at all in exchange for the NSF fee. With respect to overdraft fees, the CFPB has acknowledged that financial institutions do actually incur a credit risk when they pay a transaction that exceeds the consumer's account balance, but they take issue with the fact that this is a flat fee, it's a $35 fee, regardless of the amount of credit risk that the institution is taking on. And sometimes it's even higher than, they may be paying a $10 charge, but, charging the consumer this $35 fee. And like Ori was discussing, the CFPB has said that these fees hinder competition. They've called them back-end fees because banks advertise, free checking accounts in big letters, and then charge these fees that, these NSF fees and these overdraft fees kind of on the back end, and consumers aren't, shopping based on those fees. Let's go to the next slide. So the CFPB hasn't said that it's, a UDAP or otherwise a legal violation to charge overdraft fees or NSF fees in general, but the CFPB has been using its bully pulpit to encourage financial institutions to change their deposit account fee practices. They've been publicly releasing information about NSF fee and overdraft fees that financial institutions charge in a kind of apparent effort to shame them into changing their practices. So on this slide, you can see an excerpt of one of the charts that CFPB released in December that provides some specific information about the overdraft and NSF fees that financial institutions are charging. They've released updates to this chart several times to note changes in the fees that the banks are charging or that they have announced. So you can see that blue highlighting on this chart, those are cells that have changed since the CFPB first released this chart. And so you can see that this, this effort by the Bureau has paid off, that financial institutions, in fact, are changing their practices. And the Bureau said that, they've looked at the numbers, and NSF fee and overdraft fee revenue was 33% lower over the first 3 quarters of 2022 as compared to the same time period in 2019. And the Bureau attributed this decline to changes in bank policies. We can go to the next slide. So representments. So if a transaction is returned unpaid due to insufficient funds, the merchant might decide to represent the transaction. They might think maybe the transaction will be successful tomorrow. And there's often I think some pretty sophisticated analysis that goes into when to time these representments so that you would likely, to be successful in getting your payment. So they might represent it. And if the financial institution might charge the consumer an NSF fee each time the transaction is represented if the consumer has insufficient funds in their account each time. So because of that, consumers can be assessed, multiple NSF fees for the same transaction, and they can get caught in this cycle that we see on this slide here, where the merchant presents the item, the bank returns it unpaid and assesses an NSF fee. The merchant again represents the item. The bank returns the item unpaid and assesses an NSF fee. And this can continue if there are no restrictions on the number of times the merchant can present the item or on the NSF fees that can be charged. And, like I mentioned, the average size of an NSF fee is $35. You can see how, a $50 transaction can become more than twice as expensive if you get hit with multiple NSF fees. So we can go to the next slide. So I mentioned that the CFPB hasn't said that just generally charging NSF fees or overdraft fees, constitutes a UDAP or is otherwise unlawful. But charging NSF fees on representments does raise UDAP concerns. So in 2022, the FDIC and the New York Department of Financial Services released guidance indicating that charging NSF fees on representments raised unfairness concerns. Before this, we were mostly just concerned with deception, but making sure that NSF fees charged on representments were adequately disclosed, expressly and clearly stating in account opening disclosures or in other documents that if an item is presented multiple times for payment, fees may be applied after each presentment. And so it wasn't really until last year that regulators began raising unfairness concerns. And although the CFPB has been making it clear for a while that it does not like NSF fees, they didn't publicly state that multiple fees charged on a single transaction may be an unfair practice until the latest edition of Supervisory Highlights that was released in March 2023. And in case you're not familiar with it, Supervisory Highlights is just a regular publication. The CFPB puts it out a couple times a year, and it explains things the CFPB has cited entities for during its supervisory exams. So this is something it first said in March 2023. And in Supervisory Highlights, the CFPB explained that the assessment of multiple NSF fees on the same transaction caused substantial monetary harm for consumers totaling millions of dollars, and that the injuries were not reasonably avoidable, regardless of account opening disclosures. And that's kind of interesting because, we've made the argument that the charges are reasonably avoidable if they're clearly disclosed, because the disclosures put consumers on notice that if they don't have sufficient funds in their account, they may be charged these fees. And they could make sure they kept enough money in their account so that they could avoid these fees. The CFPB clearly disagrees with this analysis, but Supervisory Highlights didn't provide detail as to why the injuries were not reasonably avoidable. I think the idea is that consumers don't have, typically any control over or involvement in the representment of transactions, and that there's no way for them to avoid a representment once they've attempted the transaction. Supervisory Highlights noted that the CFPB directed these entities to refund consumers. And kind of significantly, it stated that, quote, virtually all institutions that it engaged with on this issue plan to eliminate NSF fees entirely. This kind of shows that the CFPB's campaign against NSF fees is working. And then another consideration here is that we understand it may just be procedurally and operationally simpler to just eliminate NSF fees across the board, rather than trying to kind of tease out which NSF fees are charged on representments versus which ones are charged on kind of the original presentment. May be difficult to kind of figure out which ones are original versus which ones are representments. Thanks. I think we can go on to the next slide now. Okay, great. Okay, now overdraft fees on APSN transactions. So the CFPB has also said it's unfair to charge consumers unanticipated overdraft fees. And the transactions at issue are those that are authorized positive, but that settle negative. So these are APSN, authorized positive, settle negative transactions. So that means that when the consumer made the transaction, they had sufficient balance in their account to cover it. But because of the delay between the authorization and the settlement, the consumer did not have sufficient funds at the time of settlement. And that disconnect between the authorization and the settlement can happen for a number of reasons, including the order in which transactions post or authorizations that result in additional holds on the consumer's account. So the CFPB has addressed this issue in a 2015 edition of Supervisory Highlights and a circular that it released last year. It also addressed it in a couple of consent orders, and we have a slide later on one of them. But essentially, the CFPB thinks that authorization and settlement practices are very complex and nearly impossible for regular people to understand. And even if you're carefully watching your account balance, you may not be able to figure out when you're going to get hit with an overdraft fee. So if we can go to the next slide. This slide talks about why it might be difficult to figure out if you're going to be charged an overdraft fee. So on April 1st, you have a starting balance of $1,000. Then on April 2nd, you have an authorization hold of $500. So it's authorized positive because you have enough money in your account for that. Now your available balance is $500. On April 3rd, the hold is released. You're back to $1,000. Then there's a point of sale transaction for $600, bringing your available balance down to $400. Then the next day, that transaction that was originally authorized on April 2nd settles for $500. And so now it settles negative because you don't have $500 in your account. So it was authorized positive, but settled negative. So these are the situations in which, or just an example of a situation in which the CFPB would say that charging an overdraft fee for the transaction that settled negative would be this surprise, unanticipated fee that would be probably unfair. And I see we have a question. Do you have any updates that apply specifically to mortgages, both origination and servicing? So I know that there were a lot of examples of this in some of the recent editions of supervisory highlights. I think one that comes to mind was a speed pay fee charged by a servicer. And they, speed pay fees can be, definitely prohibited if it's a debt collection situation, but I think this wasn't. So this was just a speed pay fee that was charged by not a party that would be considered a debt collector. And they didn't disclose it. Well, they disclosed it maybe in some other documentation that said something like, you may be charged a fee if you pay by phone. But then when you called in to pay by phone, the folks taking your call didn't again tell you that there was additional fee and that there was an additional fee for paying by phone. And it just so happened that this fee was apparently very high and a lot higher than other methods of paying. And the CFPB in their supervisory highlights called that an abusive practice because it took unreasonable advantage of a consumer's knowledge or something like that, or you might be able to explain that better. But that, yeah, and I think I would suggest that looking at some of the recent editions of supervisory highlights, there's actually a ton of fees in the mortgage servicing area that the CFPB has taken issue with. Ori or Chris, do you have comments on this?
Well, I'm just looking at this. There is a whole section in the junk fee supervisory highlights about mortgage servicing, and I'm going to touch on some of them, but we can do it now. Charging late fees in excess of what's allowed by the contract in the mortgage space, repeatedly charging consumers for unnecessary property inspections, misrepresenting PMI premiums. That's I'm not really sure that's so much of a fee issue. Some other quirky ones, but I'd take a look at the section 2.3 of the junk fee supervisory highlights on the CFPB's website for some more specific mortgage related fees.
Yeah, thanks for that question. Okay, let's go to the next slide. Okay, so the CFPB entered into a consent order with Regions Bank last year to settle allegations related to APSN transactions. And in the press release, the CFPB called these overdraft fees charged on APSN transactions, quote, illegal surprise overdraft fees, and required $141 million in consumer redress and a $50 million civil money penalty. The CFPB alleged that Regions charged these surprise fees on ATM withdrawals and debit card purchases after indicating that consumers had sufficient funds at the time of the transaction. And one kind of significant additional strike against Regions is that the CFPB mentioned that the leadership of the bank knew about this issue and could have discontinued the practice sooner, but opted not to and chose to wait until the bank had developed other fee revenue to kind of take the place of these APSN fees. So the CFPB made a big deal about that in the press release. Okay, we can go to the next slide. The last type of deposit account fees that I'll discuss are the return deposit item fees. These are fees that are charged when you deposit a check and it's returned because it couldn't be processed against the originator's account. And checks can be, of course, returned for a lot of reasons. Maybe the originator's account doesn't have enough funds in it to cover the amount listed on the check. Maybe the originator asked their bank to stop payment on the check. And the Bureau released a bulletin last year about this. And the bulletin focused on the fact that consumers just generally aren't going to know whether the check they're depositing is going to clear. They are generally have no way of knowing whether the originator has enough funds in their account or whether the originator has asked their bank to stop payment on the check and that kind of thing. So they have no way of avoiding this fee generally. And unlike a business, they may not be able to recoup the fee that they're charged. So the CFPB says that these, blanket policies of charging return deposit item fees to consumers for all return transactions is likely an unfair practice. they're okay with more targeted approaches. So if, for example, you charge return deposit item fees only when, based on kind of the face of the check, you can tell that it's not going to clear, like, for example, because it's not signed. Charging fees in those instances might be okay. Also, charging fees, for example, if someone turns in a bunch of checks, over and over again, but they're bad checks written by the same originator, charging fees in those instances might be okay. So blanket policies of charging these return deposit item fees, probably a UDAP, but more targeted approaches the CFPB would approve of. And now I'll turn it back over to Ori to discuss some of those other fees.
Thanks, Krista. Next slide. So a couple other things the CFPB has done. They've issued an advisory opinion about what they call pay-to-pay, or what industry refers to as convenience fees. Right, these are fees to make a payment through a particular channel. And the advisory opinion is based on the Fair Debt Collection Practices Act. So it applies to making a debt collection payment. If you're going to charge someone to make a payment over the phone, the Bureau said that violates the FTCPA unless the fee is expressly authorized by either the agreement creating the debt or by expressly authorized by state law. I think the opinion does raise a question about whether those kinds of fees are potentially unfair or abusive, in addition to violating the FDCPA, not just in the debt collection process. And then in the supervisory highlights that Krista mentioned and that I mentioned, these are just a few of the things that were flagged in there as UDAPs. Charging late fees in excess of the contract amount, right? If your system's set up to charge a $25 late fee, but the contract, whether it's a mortgage or whatever it is, only allows for a $15 late fee, then charging that fee is going to be viewed as unfair by the CFPB. Charging late fees after acceleration of a loan, the Bureau says is unfair because as a legal matter, you've accelerated the loan and monthly, periodic payments are no longer due. And so those payments can't be late. And so any late fees charged are no longer proper. Repossession fees that are higher than average repossession costs. So this is in the auto loan space, but I think it's an example of the kind of fee that the agency dislikes. You're purporting to be recouping your costs, but you've set your fee amount higher than necessary to actually recoup your costs. And then the last bullet there, fees that should have been waived by law are, failure to comply with various specific regulatory requirement where fees are unauthorized. And then the last one I think is a really big one, and that is payment processing fees that exceed servicers' costs for processing payments. This harkens back to the pay-to-pay issue too, and is an example. If you go back to that first slide in the second part of the CFPB's definition, right? If you're charging fees that substantially exceed the costs incurred, then it's not you're not just recovering your costs. Now it's a profit center, and they view that as potentially a UDAP, particularly if it's in a situation where the consumer is sort of already a captive, right? This isn't a fee that you can charge what you want in the market up front, but now that the consumer is locked into you and you're charging a fee, but that is disproportionate, that's problematic. So there are other things in supervisory highlights. There's a long list of these, but I think the more important point is to take away some of the principles. Next slide, please. So that takes us to the takeaways, and where does that leave you? I think there's low hanging fruit and there's slightly higher hanging fruit. The low hanging fruit is, are your fees properly and prominently disclosed, including but not limited to an account opening, right? That's just sort of standard, UDAP compliance to prevent deception. As Krista noted, that's not going to be sufficient in some cases from the CFPB's perspective, right? It's nice that you disclosed your fee. They're still going to find it problematic. But if you haven't disclosed it properly, then you've just set yourself up as an easy target. And then the other low-hanging fruit, I think, is are fees authorized by the underlying contract. And that's what I just talked about, the example from supervisory highlights is, make sure that your fee amounts are set in accordance with what you've disclosed and contracted for. Then you get into the things that are a little more challenging to look at. But among the questions that I would ask in light of all of the guidance that's come out is, are the fees that are being charged far exceeding the cost of the service being provided, right? Are they serving as a profit center as opposed to a cost recovery center? And that's going to potentially lead to a claim of unfairness, and thinking about how are you going to defend against that? Are you reviewing your fees regularly? Do you know what fees are being charged? What service are they being charged for? What are the amounts based on? Are you documenting any of that so that if a regulator comes in, either with, in the course of an investigation with the CID or an examination, if you're subject to exam authority, that you can show that these are fees that are intended to cover your costs, not just produce revenue. There's challenges here. How do you account for deterrence, right? That's not a hard cost out of pocket, but that's a purpose of certain fees. But again, if you can show an analysis in that fees have been set thoughtfully, you're going to be in a much better place than just saying, well, everybody charges that, because that is not a successful argument with the Bureau, at least in the context of negotiations, right? You might succeed better in litigation. So these are some of the questions we think companies should be asking about their fee practices going forward. Thank you all very much for attending today.